Hello, and we're going to report the CIAP Document 102. What is CIAP Document 102? It is also called as Uniform General Conditions of Contract for the Private Construction. Contains terms and conditions ordinarily established in construction contracts. What is the intention of the CIAP Document 102? CIAP Document 102 was formulated to provide the procedures, guidelines, and criteria to be used by parties in a construction contract or reference to the contract to address deficiency and/or any ambiguity. The CIAP Document 102 will contribute to the enhancement of fair contractual relationships in the construction industry. What is a construction contract? A typical construction contract consists of an agreement, general condition, drawings, specifications, and other documents. Contract. It is used to describe the combination of two sets of documents, the agreement and the contract documents. Agreement. It is used to describe the agreement signed by the owner and the contractor, excluding the contract documents. Contract documents are attached to the agreement identified therein as contract documents, including all additions, deletions, and modifications, which generally includes the following: special provisions or conditions, general conditions, specifications, drawing, and other bid documents. Special provisions or conditions are instructions which are issued prior to the bidding to supplement and/or modify the drawings, specifications, and/or general conditions of the contract. Specifications. Specifications are the written or printed description of the work to be done, describing qualities of the material to be used, the equipment to be installed, and the mode of construction. Drawing. Drawings are graphical presentations of the work, including supplementary details and shop drawings. General conditions of contract pertains to the role, rights, and obligations of the contracting parties, and the rules and procedures by which the parties and everyone concerned will be able to meet their obligation and perform the works covered under the contract. Different sections and articles. CIAP Document 102 contains these conditions which are generally applicable for all types of construction contracts to wit. Section 1. Definitions and documents. Under Article 1 there are definitions. Article number 2. Executions, correlations, meaning of terms, and intent of documents. Number 3 or Article number 3. Drawing and specifications. Article number 4, detailed drawings and instructions. Article number 5, shop drawings. Section 2, laws and regulations, site conditions, permits, and taxes. Under this section are the Article number 6, laws and site conditions, and Article number 7, permits, taxes, and surveys. Section number 3, equipments and materials. Under Section 3, there are Article number 8, General, Article number 9, Equipment, Article number 10, Materials, Fixtures, Appliances, and Fittings furnished by the contractor, Article number 11, Materials, Equipments, Fixtures, Appliances, and Fittings furnished by the owner, Article number 12, Royalties and Patterns, Article number 13, Manufacturer's Direction. Section number 4, Premises and temporary structures. Under Section 4 is the Article number 14, Use of premises, Article 15, Temporary structures and facilities. Section number 5, Protection of work and property. Under this section is Article number 16, Protection of work and owner's property, Article 17, Protection of adjacent property and existing utilities, Article number 18, Protection of life, work, and properties during an emergency. Section number 6 is the labor, work, and payments. Under these sections are Article number 19, Labor, Article number 20, Work, Article 21, Time and Completion of Work, Article number 22, Payments. Section number 7 is Contractor Separate Contractor-Subcontractor Relationships. Under these sections are the Article number 23, Separate Contracts with Other Contractors, Article 24, Contractor Separate Contractors Relations, and Article 25, Subcontracts. Section number 8, Suspension of Work and Termination of Contract. Under these sections are Article number 26, Contractor's Right to Suspend Work and Terminate Contract, Article number 27, Owner's Right to Suspend the Work, Article number 28, Owner's Right to Terminate a Contract, Article number 29, Owner's Right to Proceed with the work after reduction of the contractor's scope of work, partial takeover from the contractor. Section number 9, Responsibilities and Liabilities of Contractor and of the Owner. Under this section are the Article number 30, Contractor's Responsibility for Accident and Damages. Article number 31, Contractors' Insurance and Bonds. Article number 32, Owners' Responsibilities and Liabilities. Article number 33, Liens, Disputes, and Arbitration. Section 10 is the Owner's Representative. Section 11 is the Schedule of Time Limits. What are the importance of clear contract terms and harmonized contract documents? Many disputes in construction arise from inconsistent and ambiguous contract terms and conditions, which leads to varied interpretations and conflict between the contracting parties. To avoid disputes that may affect the completion of the work and strain the relationship of both parties, it is important that the contract documents objectively reflect the agreement and true intent of the parties. Section number 1 provides the definitions of the terms, use, and the execution, correlation, and intention of the contract documents, as well as the rules to be followed in case of conflict or discrepancy. Obligation of the contracting parties when it comes to permits and licenses and payment of taxes. Section 2 stipulates compliance with all laws insofar as they binding upon or affect the parties to the contract. The owner, with the contractor's assistance, shall secure and pay all construction permits and licenses necessary for the execution of the work. The contractor shall secure the final occupancy permit, but he shall not be responsible to the owner if without his fault the license is not issued or there was delay in its insurance. The contractor shall pay all taxes as required by the laws pertinent to the construction of the project. Who is in charge of safety and sanitation in the work premises? Pursuant to section number 4 and number 6, the contractor is in charge of the safety and sanitation at the worksite during and upon completion of work. Who has the obligation to protect the work and the owner's property from damage? Section number 5 provides that it is the obligation of the contractor to protect the work and the owner's property from damage. 9. Article 30 states that the contractor shall be primarily responsible for all safety measures in executing the work.
Good day, I am Florence Reyes Singqua, your reporter for today's video. My topic for today is a continuation of the topic Ciap Document 102, or the Uniform General Conditions of Contract for Private Construction. So to start, let's answer the question, what are the bonds and guarantees required of the contractor? Section 9, Article 31 of the Ciap Document 102 or the Contractor's Insurance and Bonds enumerates the insurance, bonds, and guarantees required of the contractor. This includes number 1, contractor's liability insurance. This is for the contractor, subcontractors, and owner. 2, accident insurance for workers. 3. Contractors' fire insurance. 4. Contractors' performance and payment bonds. 5. Contractors' guarantee bond. And lastly, contractors' guarantee warranty. Is the owner required to obtain the insurance? In Article 32.02 of the Ciap Document 102, it is stated that the owner may opt to obtain an insurance that will protect him from his contingent liability. So, that means that the owner has the choice if he would opt to obtain or not an insurance. Next, is the subcontractor also required to obtain bonds and insurance? It is stated in Article 33.03 that the subcontract must require the subcontractor to obtain the same bonds and insurance coverage as are required of the contractor. But what is the difference in the contractual relationship between the owner and the separate contractor and between the contractor and the subcontractor? The difference in the contractual relationship between the owner and the separate contractor is that the owner shall provide for the coordination of the work performed by the separate contractor with the work of the contractor. On the other hand, the difference in the contractual relationship between the contractor and the subcontractor is that the contractor is fully responsible to the owner for the acts and omissions of his subcontractors. Is there a contractual relationship between the owner and the subcontractor? The answer is that the consent of the owner to the contractor's engagement of a subcontractor shall not create any contractual relation between the subcontractor and the owner. However, is it required to appoint an owner's representative? In Section 10, Article 34, or owner's representative, it provides the appointment of the representative of the owner and the extent and limitation of the authority granted to the representative. Is the owner required to make advance payment to the contractor? Article 32 or the owner's responsibilities and liabilities provides that the owner shall pay the contractor an advance payment, which shall be used for mobilization, purchase of materials, and shall be recouped pro rata in the progress billings. Next, can the contractor commence with the work even without the consent of the owner? Article 21.01, Notice to Proceed when required, states that premature commencement of construction shall be at the constructor's risk and the owner gives the contractor express or implied authority to do so. How can the owner ensure the quality and efficient execution of the work? Section 6, Labor, Work, and Payments provides that the owner shall at all times have access to the work and shall provide sufficient number of inspectors while work is in progress to ensure quality. Is substitution of materials and equipment allowed? To answer, Section 3, Equipment and Materials provides that all materials and equipment must conform to all laws that are in force and applicable during the period of construction, and that the contractor shall bear all damages by reason of any delay in the work arising from failure to comply with such laws. What constitutes change order and adjustment of contract price? Section 6, Article 20 describes the circumstances that are covered by a change order and that warrant adjustment in contract price and if necessary, corresponding adjustments in completion time. What are the conditions for the release of payments to the contractor? Article 22.01 provides that the contractor shall submit to the owner the breakdown of work and corresponding value of the contract amount, showing the value assigned to each part of the work. What is progress payment? The contractor may submit periodically but not more than once each month a request for payment for work done. Each request for progress payment shall be computed from the work completed on all items listed in the breakdown of work and corresponding value, less a retention of 10% of the progress payment of the contractor. On the other hand, what is retention money? Retention money is progress payments subject to retention of 10%. The purpose of retention is to cover uncorrected discovered defects and third-party liabilities. Last, what are the documents to be submitted by the contractor to the owner before final payment? This includes number 1, Certificate of Final Bidding Occupancy; 2. Certificate of Final Inspection of Electrical, Telephone, Sanitary, Mechanical, Water, Gas, Safety, and other utilities. 3. Original and 3 sets of prints of as-built drawings of electrical, sanitary, gas, telephone, and mechanical works. Number 4. 3 copies of Directory of Panel Boards and List of Circuits. Number 5. 3 copies of instructions and manual for operating and maintaining of fixtures and equipment. Number 6. 3 copies of keying schedule, and lastly, release of liens arising under the contract or the sworn statement or indemnity bond. Thank you. That is the end of my lesson for today.
Does the release of final payment relieve the contractor of liability for any defect in the work? After release of final payment and the acceptance by the owner of the work, the contractor is still liable for any defect in the work if the defect is hidden, the owner's acceptance of the work was made with reservation to specific portion of the work, inferior work or work which does not comply with the drawing specification and is apparent upon the inspection by the owner within 1 year from final payment, and number 4, hidden defect discovered within the warranty period or within 1 year from posting of the guarantee bond. The contractor is likewise liable for the damages if the edifice falls within 15 years of completion of the structure on account of defects in the construction or the use of materials of inferior quality or due to any violation of the terms of the contract as provided in Article 1723 of the Civil Code of the Philippines. When shall the owner release the retention money? The amount retained by the owner under the provision of contract shall be released not later than the expiration of the period of making good of non-defect. In default thereof, not later than the expiration of the period during which the contractor shall complete corrective works on punch list items upon the posting of the contractor's guarantee bond. So, what does period of making good of non-defects mean? The expression period of making good of non-defects shall mean a period not more than 30 calendar days calculated from the date of receipt by the contractor of the last item in the punch list. If after release to the contractor of final payment or retention, there are still unpaid claims of subcontractor and/or supplier, is the owner obliged to pay such claims? According to Section 9, Article 33.01 provides that as a condition of final payment and or release of the retention, the contractor shall release the work from any legal lines. Can the owner take possession of and use any completed portion of the work prior to overall completion? According to Section 6, Article 20.10, the use of completed portion of work provides that the owner may take possession and use any completed or partially completed portion of the work prior to overall completion and shall issue a certificate of completion for such a portion taken over the release retention as required by the contract. What is substantial completion? According to Section 6, Article 20.11, or the substantial completion and its effect, provides that there is substantial completion when the contractor completes 95% of the work. What is a punch list? Punch list, as defined under Article 20.11c, is the list of defects found or discovered on the completed work and which should be received by the contractor not later than 30 days from date of substantial completion. What are the grounds for the suspension of the work or termination of the contract? According to Section 8, or the suspension of work and the termination of contract, it illustrates the condition by which the contractor or the owner may suspend the work or terminate the contract. Are there prescribed periods within which the contracting parties shall perform their respective obligation under the contract? Ciap Document 102 provides that prescribed time limits for the execution of the contract condition in order to facilitate the performance of the work covered under the contract. Section 11, or the schedule of time limits. What circumstances necessitate an extension of time? According to Article 21.04, or the extension of time, provides that contractor shall be entitled to an equitable adjustment of a completion time subject to certain conditions, and also states that delay in the payment of any progress billing shall automatically extend the completion time by a period equal to the delay. What is the penalty for delay? According to Article 21.05, provides that upon failure of the contractor to complete the work within the completion time, the contractor shall pay the owner liquidated damages in the amount stipulated in the contract as indemnity, but shall not exceed 10% of the total contract price, and covered by the Article 29.06.
Good day everyone, this is Alvin Ojos from BSc 3B and this is a continuation of the Ciap Document 102. In case of disagreements in interpretation and implementation of the contract conditions, how can CIAP help resolve such disputes? Section 9, Article 33.04 provides that in case of disagreements, the parties may engage the services of an adjudicator to resolve their disputes, and that if either of the party disagrees with the resolution of the adjudicator, the parties may submit such disputes to arbitration. So the adjudicator is the one who adjudicates, or the one who makes a formal judgment or decision about a problem or disputed matter. One of the implementing arms of the CIAP is the Construction Industry Arbitration Commission, or the CIAC. CIAC is tasked to provide alternative dispute resolution facilities for the speedy and equitable settlement of claims and disputes arising from or connected with construction contracts in the Philippines. The CIAC offers mediation and arbitration as ways of reconciling differences between disputants with the help of people who are familiar or knowledgeable with the construction industry. What is mediation? Mediation, as defined under Section 6 of the CIAC Mediation Rules, shall mean a voluntary process in which a mediator, selected by the disputing parties, facilitates communication and negotiation and assists the parties in reaching a voluntary agreement regarding a dispute. What is arbitration? Arbitration is defined as the investigation and determination of matters of differences between contending parties by one or more unofficial persons called arbitrators or referees chosen by the parties. It is intended to avoid the formalities, the delay, the expense and vexation of ordinary litigation. How can interested parties avail of CIAC facilities? If a dispute arises, a party may initiate the mediation by delivering a written request for mediation to the other party in accordance with the CIAC mediation rules, or if mediation fails, a request for arbitration in accordance with the CIAC rules of procedure governing construction arbitration. Are there recommended dispute resolution clauses? For parties entering into a contract who wish to have future disputes referred to mediation and/or arbitration, the following dispute resolution clauses may be included. First is the mediation and arbitration by CIAC. Any dispute or differences arising out or in connection with this contract shall be referred to the Construction Industry Arbitration Commission or the CIAC for settlement. First, through mediation under its mediation rules, or failing which by arbitration under its rules of procedure governing construction arbitration by and indicate the number of arbitrators, and the appointment of mediator or arbitrators shall be made in accordance with such rules. The place of mediation or arbitration shall be indicated. Next is the period of arbitration by CIAC. Any dispute arising out of or in connection with this contract, including any question regarding its existence, validity, or termination, shall be referred to and finally resolved by the arbitration under the rules of procedure governing construction arbitration promulgated by the Construction Industry Arbitration Commission by indicate the number of arbitrators to be appointed in accordance with such rules, and the place of arbitration shall be indicated too. By negotiation among the parties with time frame, mediation and arbitration by CIAC. Any dispute or differences arising out or in connection with this contract shall be settled by negotiation within a non-extendable period of 30 days from written demand by either party. If such negotiation should fail, the same shall be referred to the Construction Industry Arbitration Commission for settlement, first through mediation under its mediation rules within a non-extendable period of 48 days, or failing which by arbitration under its rules of procedures governing construction arbitration by indicate the number of arbitrators, and the appointment of mediator or arbitrators shall be made in accordance with such rules promulgated by the CIAC. The place of mediation or arbitration shall be indicated. What are the issues that can be submitted for mediation or arbitration? The jurisdiction of the CIAC may include, but is not limited to, the following. First is the violation of specifications for materials and workmanship, violation of the terms of agreement, interpretation and/or application of contractual provisions, commencement time and delays, maintenance and defects, changes in contract cost, payment default or employer or contractor, and the amount of damages and penalties.
Good day, I will be discussing all about the Section 11 schedule of time limits. Number 1 is contract time. Number 1.1, contract time reckoning. The time limit according to Article number 21.02, the contractor shall commence the work within 7 days from receipt of notice to proceed, unless the NTP provides for a later date. Number 1.2, the request for time. The time limit according to Article number 21.04 to be filled within 15 days from occurrence of event which caused delay. Number 2 is the contract sum. 2.1, breakdown of work and corresponding value. Time limit according to Article number 22.01 to be submitted within 15 days from receipt of the notice to proceed. Number 2.2, claim for extra cost. The time limit according to Article number 20.08, notice to be given to owner within 15 days after receipt of instruction involving extra cost, or after recognition of delay due to owner's fault. Let's go to number 3, the progress or final payment. Number 3.1 is the owner's action on payment request. Article number 22.05 says that the time limit is to be made within 30 days after receipt of request for payment. Number 3.2, owner's action on final payment request. Article number 22.05 says that the time limit is to act within 30 days from receipt of the request for payment. Number 3.3, the delayed payment. Article number 22.05 says that delay in payment of the amount due shall entitle the contractor to interest from due date based on the 30-day loan rate of the Land Bank of the Philippines. Number 3.4 is the release of retention. Article number 22.11 says that the time limit is to be released not later than 60 days from substantial completion upon posting of contractor's guarantee bond. Number 4 is the substantial completion and its effects. Article number 20.11 says that substantial completion is attained if the contractor complains 95% of the works or the owner approves the contractor's billing completing at least 95% of the works unless the owner can establish that the unfinished portion prevents the normal use of the completed portion. The owner may issue a certificate of substantial completion or equivalent document, but the date of document is not controlling if substantial completion is shown to have been attained earlier, unless the contractor accepts the certificate without taking any exceptions thereto in writing within 15 days from receipt of the certificate. Let's go to number 5, the correction of work. Number 5.1 is the issuance of punch list. Article number 20.11 says that the owner shall issue the punch list or lists which the contractor must receive not later than 30 days from date of substantial completion. The owner may add to the punch list items but only as to corrective work in the original punch list, not later than 60 days from substantial completion. Number 5.2 is the correction before or after final payment. Poor or inferior work apparent upon inspection to be condemned and contractor notified to enable him to correct, remove, and replace the same. Owner has 1 year from date of final payment to condemn the poor or inferior work. Otherwise, instructions to remove or replace such shall be treated as change order. Number 5.3 is making good of known defects. Article number 20.12 and 20.13 says that 30 days from receipt by the contractor of the last item in the punch list.
Hello guys, this is my report. The continuation of section 11, schedule of time limits. For the number and title, number 6, contractor's right to suspend work or terminate contract. The time limit, contractor may be suspend work or terminate contract upon 15 days written notice to owner for any of the following reasons. Number 1, if any court or other public authority orders work to be stopped or suspended for 90 days through no fault of the contractor or his employees. Number 2, owner fails to pay contractor for approved requests for payment within 30 days from receipt. Number 3, if owner fails to pay contractor with agreed sum within 30 days after its award by arbitrators. Number 4, if the owner suspends the work without case for more than 15 days without contractor's consent. Number 5, if the owner fails to deliver at the construction site owner supplied or furnished materials or equipment for work along critical path beyond 15 days after its scheduled delivery time. Last, if approval of variation orders for additional works along the critical path is delayed between or beyond 15 days after submission for approval by the owner, and the reference number is 26. Next is owner's right to terminate contract. Time limit is may be done immediately and without notice if contractor should: number 1, declare bankruptcy, become insolvent or assigns his assets for the benefit of his creditors or appointment of trustee or receiver for contractor or any its property. The reference number is 28.01. Next is, may be done after giving 15 days written notice the contractor or to his surety of if contractor should. Number 1. Disregard or violate provisions of the contractor's document or owner's instructions. Number 2. Fail to provide skilled independent workmen or suitable materials or equipment. Number 3. Fail to make prompt payments to subcontractors for labor or materials or equipment. Number 4. Disregard the authority of the owner's representative. Number 5. Violates in any substantial way any provisions of the contract documents. Last is, repeatedly delays prosecutions to work per agreed construction schedule and or PE, PERT, or CPM plus any time extension duly granted the contractor. The reference article number is 28.02. Next is number 8. Disputes. The time limit. The owner or his representative shall act within a period of 15 days on all matters under the contract requiring the owner's approval, acceptance, or decision. If the contractor disagrees with the determination by the owner or his representative, the same shall be submitted to an adjudicator to be jointly engaged by the parties within 15 days before the commencement of the work. If either party disagrees within the resolution or the adjudicator, such shall be deemed by a dispute that may be submitted to arbitration. The reference article number is 33.04 and 35.05. Last is the guarantee bond. The time limit of this number and title is to be furnished the owner upon release of the retention and shall be effective for a period of 1 year commencing from the date of acceptance as guarantee that all materials and workmanship installed are of good quality. The reference article number is 31.05. That's it. Thank you.